Hello friends, my name is Saket Sharma and I am working as a junior research fellow in Cartels Institute for Regulation and Competition. Today we will be dealing with horizontal agreements and their types. As you know, this will be an introductory module on horizontal agreements covered under competition law, and it will deal with basics of horizontal agreements, types of such agreements, reasons for collusion by businesses, and regulation of such agreements by the competition laws of various countries. We will cover horizontal agreements like market allocation, price fixing, bid rigging, and it will also cover, of course, the cartels and a very brief overview of what are the different ways and means in which competition authorities regulate and try to detect and penalize cartels. As you people know, the competition law mainly focuses on three areas of anti-competitive behavior. First relates to anti-competitive agreements, second relates to abuse of dominant position, and third relates to regulating mergers and acquisitions. So here, anti-competitive agreements can be further divided for sake of convenience, we can say, into horizontal and vertical agreements. And this module will be dealing with the horizontal agreements, the introduction of horizontal agreements, the basics of horizontal agreements. And as you people know, the competition law is more an economic law, and to really understand why the businesses collude, and try to behave in anti-competitive manner, it's very important to link it with the economics behind this, because market structures also are the reasons. The different type of market structures may be helpful to the market participants basically to indulge into anti-competitive practices. And we will discuss as why collusion is facilitated by a different sort of market structures. So from a monopoly market structure to a competitive market structure, in between there can be duopoly, there can be oligopoly, and there can be monopolistic competition. But if keeping in view horizontal agreements and cartels, we can see that cartels are more found in oligopoly type of market situations. So coming on, and cartels have been seen as one of the egregious form of anti-competitive behavior, and they are given a stringent treatment across the countries world over. Broadly, for the purposes of competition law, the agreements between the market players may be classified either as vertical agreements or horizontal agreements. And horizontal agreements are agreements which occur between enterprises at the same level and have potential to adverse affect the competition. And cartels are one form of horizontal agreements. So, what is an agreement? That question also arises first. So, and how an agreement can restrain a trade or business. So, if we see, it relates back to the earlier Old English common law system doctrine of restraint of trade, which can be called the precursor of modern competition law. And put simply, a restraint of trade is a provision, it's sort of agreed provision that is designed to restrain another's trade or prohibit agreements unless the reasonableness of that agreement could be shown. So that can be anti-competitive. So restraints can be reasonable also, but if the restraints are unreasonable and are aimed at curbing competition, aimed at harming consumers, then those will be covered under the Competition Act. And there is always a possibility that market players coordinate their actions to achieve a position in the market so that they can indulge in anti-competitive practices. So why the firms collude? Basically, firms collude to gain market power, and so that they can set the prices, they can control production, and thereby they can control the market to their favor. Thus, the firms can collude, control production and raise prices and earn profits while without doing much at innovation front, you can say. And firm or enterprise, it's an entity which uses capital, labor, land, materials, we call generally, to produce good or provide a service for sale. And firms can have different market relations with each other. Horizontal relation means where the firms are producing the same or similar goods and services. And horizontal agreements can be in the nature of fixing prices, restricting quantities, allocating territories, rigging bids. On the other hand, we look at the vertical relation. Here, the firms producing different goods or services at different stages or different levels of production in the distribution chain. Here, the nature of the agreements will be resale price maintenance, exclusive territories, exclusive dealing. So here the firm at an earlier stage of chain is upstream and one at the later stage of production is downstream firm. So this was all very basic about what are horizontal and what are vertical agreements. Horizontal agreements thus are sort of agreements between entities at the same level of distribution, and verticals which are a different level of distribution, which can be between a manufacturer and a distributor or between a wholesaler and a retailer. Really speaking, agreements through which restraints are imposed between competitors have traditionally been denominated as horizontals, and those in which the restraints are imposed between firms at different levels are called verticals. But in the end, it can be said that all anti-competitive effects are of necessarily horizontal in nature, since competition is more a horizontal concept. But that such horizontal effects can result from either horizontal agreement or vertical agreement. So the competition will be horizontal, but it can be a resultant of a horizontal or a vertical agreement. So vertical agreement, if we take an example of let's see a tire manufacturing process. There is a rubber supplier, then there is a tire manufacturer, then there is a tire wholesaler, and then there is a retail shop. So see the chain of from supplier to the shop, there is a chain, and those are at different levels. So this is a vertical agreement. And now when we analyze the horizontal agreements, so we will see the relation between different rubber suppliers which are at the same level, or maybe with different tire manufacturers or different tire wholesalers. So this is the difference. So vertical agreements, the relation is more of purchaser and seller relationship, where in horizontal agreements the relation is between competitors, and this is important because when competitors themselves plan not to compete but to collude, then it can have more adverse impact on competition and it can lead to competitive harm and consumer harm. This is the reason why we see that vertical agreements are given a lenient treatment than horizontal agreements under the competition law, and most of the vertical agreements are sort of the business practices which we see in daily life between different firms at different levels of distribution or production chain. I think the reason for this is now quite clear, that why horizontal agreements are seen as more harmful to competition than vertical agreements. And horizontal agreements like price fixing, market sharing, by their nature are almost always considered detrimental to competition. So they by their nature are detrimental to competition, and this is the reason why they are given a bit stricter treatment. And normally agreement can be in various forms, like when competitors meet, as old quote goes, people of the same trade seldom meet together, even for merriment and diversion, but the conversation ends in a conspiracy against the public or in some contrivance to raise prices. So competitors, if they are meeting even at a business, even at their some personal event, so it can be seen that the meetings or the discussions may end up in discussing prices or discussing cost costing or discussing the discounts. So these are sort of discussions which can be taken into account by competition authority later on. So this is a reason that normally the definition of agreement is quite wide when we see it from a competition law perspective, so as to cover all type of business practices, all type of decisions, all type of interactions between the competitors, and so that the anti-competitive conduct is taken care of properly. So what are the different types of horizontal agreements? We will cover them in a bit more detail. So there can be innumerable ways, as we've seen, then the ways business can interact with each other, and they can try to agree, try to explicitly agree on some things and implicitly also agree on some things. So there can be explicit collusion or there can be a tacit collusion, and collusion can therefore take various forms, and let us discuss some of those forms one by one. Price fixing. So collusive price fixing is an agreement regarding pricing between business competitors selling the same product or service. Again, it can take various forms. So here they mutually set the prices they want to charge in marketplace, and let us assume there are 4 cement manufacturing firms in a market, and they fix prices and control production. Therefore, whenever they control production, whenever they are charging the more prices, so in the end they are trying to create a scarcity in the market, and therefore they try to raise the prices also. Sometimes they even can fix prices as far as what are the discounts they are giving. So, or maybe they can agree on when to eliminate discounts from the market. So other price fixing agreements can be jointly predetermining the size of profit margins or extent of price level increases. So there can be different ways. Agreements to adhere to published prices. So if they have published some prices, to adhere to those prices is also one of price fixing agreement. Agreement not to sell unless it is sold on the agreed terms. So in some cases we can see even trade associations play an important role, and even we have seen, and we will cover this with more detail in our next module as to how trade associations play a part in facilitating collusion sometimes. So this can be through like agreement on standard of pricing formula for the products. So what can be the pricing formula? So if this, and then agreement regarding providing or eliminating method of discounts, agreement on credit terms which will be offered to customers. So that will be covered under the price fixing agreements. Sometimes firms even agree that they will eliminate goods and services offered in the markets which are being offered at low prices. So eliminating the low prices goods, demand for the high priced goods will increase, and this way this can also be one of the ways in which price fixing can be done, thereby limiting supply and raising the prices. Another what I can think of another form of is like agreement between cartel members not to change or reduce prices without notifying each other. So this can be one of the way to keep a check on the cartel. So if someone deviates from the cartel, then there can be problem later on for that specific member. So from the nature of price fixing agreements, which I have discussed in detail here, such are aimed at furthering the goal of members of those small member of the few group of people in the cartel, and so they earn huge profits at the expense of the consumers and harm to the economy as such. Next important thing is market sharing agreements. So this can be in the form of allocation of markets, geographic market allocation as it's called, an agreement between competitors not to compete within each other geographic territories. So Under such agreements, the competitors agree to divide amongst themselves specific territories. They can also agree on dividing customers, or they can agree on dividing type of products. And such actions are restrictive in nature. They are really very restrictive in nature because they leave no room for competition in the market. For example, an agreement amongst competitors to allot certain customers to particular sellers and to allocate or divide sale territories would be anti-competitive and will be covered under the market sharing anti-competitive agreements. And one can really see such type of things happening around, like there is a trucking cartel in the news. One can hear about trucking cartel in India, and even MRTP Commission earlier passed cease and desist order against Bharatpur Truck Operators Union. So these things are somewhat like prevalent, and with more awareness, there will be more awareness regarding the competition law. Only then such sort of anti-competitive practices can be checked. Another very important practice, which is again limited, is controlling output or limiting output, controlling production and controlling technological development. So cartels, it said, they tend to enjoy the quiet life. So what is this? What is it? Is it like a scenario? There can be a scenario where competitors agree to restrict and control the production, thereby controlling the supply. So if they are controlling the production, they are controlling the supply of the products and services in the market. And this can be done through various forms and various agreements. They can set production volumes, they can agree on sale volumes. And what is the object? What is the object behind doing all this? The object is to create scarcity in the market, and then the prices will rise on their own. And such agreements lead to deadweight loss in the society. Another fourth type of agreement, I will say, is called bid rigging or collusive bidding agreements. So this is a form of price fixing and market allocation which takes place, generally speaking, in a bid rigging agreement. And what exactly is a bid rigging? It happens when bidders collude and keep the bid amount at a predetermined level. So before going into the tendering process, the tender can be for a private enterprise or for a government, and government goes into large number of tenders. So all the competitors themselves decide who will be the bidder, and they will try to manipulate the competitive bidding process and thereby causing loss to exchequer. So bidders could be actual or potential ones, but they collude and act in concert, and they effectively raise prices. And there are different ways how bid rigging takes place. So let us take example of subcontract bid rigging. What is it? Under this type, the conspirators agree not to submit bids, or maybe sometimes they will agree to submit cover bids that are intended not to be successful, on the condition that some part of the successful bidder's contract will be subcontracted to them later on. So this is called subcontract bidding. And another type of bid rigging is complementary bidding. It is also known as cover bidding or courtesy bidding. What it involves is a situation where some of the bidders bid an amount which is too high or contains unreasonable conditions which are unacceptable to the tender. So that is for sure, they won't be taken on board. And in a sense, this gives an impression that there are a number of players taking participation in the bid process, but in reality they have already decided who will be the winner, and they are trying to manipulate the competitive tendering process, and thereby they will charge unreasonable high prices to the tender. Another type of thing is bid suppression, which occurs when some of the conspirators agree not to submit a bid so that another conspirator can successfully win the contract. So you can see there are various forms of bid rigging. Another which comes to my mind is bid rotation, and this occurs generally. It occurs like bidders take turns being designated as a successful bidder. So this can be, example can be a conspirator is designated to be the successful bidder on certain contracts, and some other are designated on different contracts. So this is sort of market allocation. So bid rigging or bid rotation here will be in nature of price fixing plus market allocation, where the conspirators allocate, or we can say apportion markets, products, customers or geographies, so that they will have a fair share, and in this way they raise the entry barriers of the market also. So all these discussed bid rigging forms like bid suppression, bid rotation, complementary bidding or subcontract bidding, one can see that even in one bidding process, these all things happening together also. So these can happen in one process also. So now these are the four main types of horizontal agreements which are seen as very problematic and which can cause adverse effect on competition. So this is what we call a cartel is. Very simply we can say what a cartel is: an agreement between competitors not to compete with each other. And we can say the cartels are very old phenomenon. Even in Arthashastra, Chanakya visualized that there are price fixing cartels, and there are price fixing like cartel situations. Therefore, we can see in Arthashastra there are prescribed standards and punishments for dealing with traders who indulge in such sort of anti-competitive cartels and practices. We look at OECD recommendations of 1998 regarding hardcore cartels. They see cartels as the most egregious violations of competition law, and therefore cartels worldwide are seen as most pernicious form of anti-competitive activity, and one can see the existence of cartels at international and national level also. So cartels, what exactly is a cartel? If we look at a very specific definition and given by OECD, it's an anti-competitive agreement or an anti-competitive concerted practice or an anti-competitive arrangement by companies to fix prices, make rigged bids, submit collusive tenders, establish output restrictions or share quotas or divide markets by way of allocating customers, suppliers, territories or lines of commerce, and they are seen as the most egregious violations of competition law. Thus, the three common components of a cartel can be: there is an agreement, which the second part is between competitors and to restrict the competition. And again, the cartels, as I've already discussed, they can agree on matters such as price fixing, total industry output, sharing markets, allocation of customers, allocation of territories, and establishment of common sale agencies and divisions of profits, and or a combination of any of these things. And generally it has been seen that cartels try to conceal their activities to avoid detection. And one can see quiet life agreements in cartel cycles, which implies that cartels become passive for agreed time to avoid detection. It is also seen that continuation of cartels is sometimes ensured through retaliation threats. In such a case, cartel members retaliate through temporary price cuts to take business away from a cheating member. So there are various ways in which stability of cartel is tried to be ensured by different cartel members. And one can see the regulation of cartel activity has become the priority of competition authorities worldwide, and the main reason is that they go beyond the basic thing of the competition, that competitors collude, which is of course seen as the most pernicious form of anti-competitive activity. And there are many cartels like international lysine cartels, international vitamins cartel, airlines cargo cartels, and there are DRAMs, random access memory related cartels, which have been fined and prosecuted at various levels in various jurisdictions. To take example of international vitamins cartels, in which leading producers of vitamins including Roche of Germany and other firms from Japan and France, they formed a very big cartel dividing the world market and price fixing for different types of vitamins in 1990s. And the duration of cartel was over 10 years. And later it was prosecuted and heavy fines were imposed on them. So this shows that the cartels, although they exist at international levels, but they can have effect on domestic level also. So the price will rise at the national level also. So now it's better for us to explain, to see what are the various market structures which facilitate, or because this will be very helpful in detection of a cartel also. So what is the market structure which facilitate the collusion? And the market conditions really play an important role, and when one looks at the oligopoly market structure with homogeneous products where cartels can emerge and operate easily, and actions like restricting industry outputs, fixing prices, these all can be found in such sort of oligopoly market conditions where their entry firms are, where the firms are concentration level is high. So high concentration in any industry implies lesser number of competitors, and if they are less, they can easily collude and coordinate the prices. High entry and exit barriers are again a reason for market players to collude and fix prices, because there will be less threat to new competition at that time. And firms, if they are collectively enjoying high market power, they will be more easily colluding. Homogeneous products are again another example where you will find more cartels, and stable demand and easy availability of prices of rivals, easily availability of pricing strategies. So all this can lead to price fixing and cartelization. These will help in cartelization. So further, history of collusion in an industry will also indicate that there can be reasons to see that, like cement industry or trucking industry, these have been seen that there exist cartels in these industries which are very difficult to detect. Sometimes it has been seen that active trade associations act as facilitator to cartels. Why cartels are bad? Why they are seen as supreme evil of antitrust? And why they are seen as cancers on the open market economy? Because they raise prices, restrict supply, inhibit innovation, and therefore what is the resultant? It is artificially concentrated markets, which leads to waste, which leads to deadweight loss, and which leads to inefficiency and distortions in prices. The higher the prices of the goods and services due to cartelization, it also forces some buyers to move or either to exit the market, and this is generally called lost volume effect in economics. And one can see when the production is controlled, the prices will rise, and when the prices will rise, the cartels will try to garner all those profits. So thereby they are limiting production and creating an artificial scarcity in the market, and there can be direct damages to the consumers which have to pay overcharges. Another effect which is seen is the umbrella effect. It's like sometimes the cartelized products can be the inputs to the other markets. So raise in prices of cartelized products will lead to raise in prices of other products also. This is called umbrella effect. So following reasons there are various reasons which depict the ill effects of cartels, like they lead to increase in prices, increase in price of materials which act as inputs for other businesses. It will also lead to reduction in investment. It will lead to deadweight loss in the society, and the cartel members do not tend to innovate. So all this leads us to one conclusion, that cartels are pernicious form of anti-competitive behavior. This is the reason. Now coming to the standard of proof, how these are proved. Obvious question arises, why a cartel is presumed to have an reverse. So normally we see in most of the countries the approach is a stricter treatment to cartels, and so, or also what we call a carrot and stick approach. Stick approach is like levying heavy penalties, and carrot is like designing the leniency programs. And in proving a cartel agreement, both direct and indirect evidence can be relied on. Direct evidence, like what we call a smoking gun evidence, doesn't require inferences to establish the alleged agreement. Generally, it is rare to find such direct evidence in cartel cases. But circumstantial evidence, from which the cartel or anti-competitive behavior can be inferred, is very useful in proving a cartel situation. This is the reason that more and more countries have this, rely on circumstantial evidence, and they rely on dawn raids, and they rely on search and seizure to collect evidence which helps them in proving the existence of cartel. And one can see like presumptive rule or per se rules as far as proving cartels is concerned. Direct evidence includes written agreements among cartel members, although they try hard to conceal such things, but sometimes they can leave such sort of written evidence also. Or it can be attended a meeting, and it can be a meeting between competitors, evidence related to that, or a memorandum written with the company. So such sort of direct evidence can be there, and circumstantial evidence is very useful in supporting the direct evidence, and it may also prove existence of cartel by itself sometimes. So recently competition authorities, it has been seen, are making use of new techniques and tools of evidence gathering and information technology forensics, and complementing it with the traditional methods of on-site searches, unannounced raids, seizure of records, and witness statements to prove the existence of cartels. So there are various, so like if one sees the example of lysine cartel, in which Department of Justice of US and Federal Bureau of Investigation coordinate with their efforts to detect and fight the cartel. Okay. But there can be horizontal agreements which can have competitive, or which can be exempted from the purview of Competition Act, and the example of such can be joint ventures or export cartels. Joint ventures can not be said that all horizontal, it really can't be said that all horizontal agreements are anti-competitive. Joint ventures can be related to joint research and development, production and distribution activities, so that economies of scale and scope can be enjoyed. So they are exempted. Export cartels are generally exempted from the purview of national competition laws because they do not affect competition in the domestic markets. So we have already seen that there is a good amount of detection and fighting of cartel, and there is a convergence. There is a convergence in international field on how to fight and detect cartels, and there is a lot of coordination going on between different agencies. And leniency programs have been developed. We have seen such programs in US, such programs in European Union, even in India there is such program. What is leniency program? It's also called immunity or amnesty program. It comprises of rules of granting reductions in penalties to firms or individuals who are involved in cartels, and those firms tend to agree that they will discontinue their participation and coordinate and cooperate with the competition agency. On these grounds, a leniency is offered to such sort of persons. And on one hand, these are the carrots used to detect cartels. Then there are sticks, which includes heavy penalties, new and improved prosecution techniques, use of IT forensics for evidence collection, and so on. So this carrot and stick approach, and sometimes we've seen, and this is a trend like in UK. In 2002, the cartels were criminalized. In US, they have been given criminal sanctions since long. So criminal sanctions are also being imposed, individual liability is also being imposed, and sometimes disqualification of directors of firms is there, so that effective design of fighting cartels can be obtained. But this is an area which is really tough, and even there is a lot of convergence and a lot of coordination emerging in, but on the other way, firms are trying to be more smart and trying to cartelize in more different ways, which are really difficult to understand. So this module dealt with regulation of horizontal agreements, which are anti-competitive in nature. It defined various sort of agreements and types of agreements, standard of proof. It give details of such sort of agreements like price fixing, bid rigging, controlling production. It also talked about cartels, which can be at international level or national level, and which have a very pernicious and anti-competitive effect on consumers, businesses, and the economy as well. So this is all. So then the next module will deal specifically with horizontal agreements in European Union and US. So if you want to read more about horizontal agreements and their types, there is a list of detailed references in the modules which you can go through and enhance your knowledge on this subject area. Best of luck. Thanks.